The Supreme Court declined to hear an appeal from Ronald Hittle, a former California fire chief who claimed he was fired for his Christian faith. In a dissent written by Justice Clarence Thomas and joined by Justice Neil Gorsuch, Thomas criticized the 1973 precedent from the case McDonnell Douglas Corp versus Green, which set a three-part test for proving workplace discrimination. First, the plaintiff must prove they belong to a protected group or class. In Hittle's case, it would be a religious group, and connect the negative action taken by the employer to the protected classification. The employer is then allowed to rebuttal with a legitimate justification for the negative action, such as a firing. The plaintiff will then rebuttal again and demonstrate the employer's reasoning was pretext or a false reason for discrimination. Hittle argued in the case he was dismissed after attending a two-day Christian leadership conference on city time. The city contended that Hittle was expected to attend a general leadership program and cited a history of insubordination as justification for his termination. A federal district court and Ninth Circuit Court of Appeals sided with the city, ruling Hittle failed to prove a pretext for religious discrimination. Thomas argued the framework has created confusion among lower courts, making it harder for employees to prove discrimination. But the Supreme Court has generally sided with plaintiffs who allege religious discrimination in recent years. In 2023, the Supreme Court unanimously decided in favor of a mail carrier who lost his job after seeking religious accommodations to observe the Sunday Sabbath.